everyone, it's me again. I'm in the same outfit because we're doing a two-parter here. Just kidding. We are. That's why I didn't go change. It's not a new day. It's the same day. And today we're going to talk about our medical powers of attorney. So last episode I talked about our financial power of attorney. Similar to that, now we're going to do our medical power of attorney for medical decisions. Again, why we're unable to make those decisions while we're alive. Again, powers of attorney live. When we die, they die with us. So again, these are for medical decisions. Say that you're in a coma, you're not able to advocate for yourself, or you're intubated, or you're just not able to make those medical decisions for yourself. The doctor's going to come in and ask you and you're not able to do it. You have a medical power of attorney for them to rely upon through your agent. So again, looking at my notes, that you, through this medical power of attorney, are going to delegate these medical decisions that you have decided for yourself in the event that you're unable to communicate those to your doctor. In our powers of attorney, we have a section that if you have any kind of special provisions or limitations, I've had clients who have religious beliefs, unable to donate blood, receive blood, you would put those in there. I know the Jehovah's Witnesses have that belief, so we also have a more religious-based power of attorney for Jehovah's Witnesses regarding the transfusion and receiving of blood. Also, the Catholics have also their own kind of more religious-based power of attorney for medical decisions based upon their faith. So we can also kind of curate that for your beliefs in that sense if you have any of those. So that's good to know. Then we have when this becomes applicable. Again, with a medical power of attorney, it's always durable. We talked about this in the last video. Durable means now. It is not affected by your ability to make these decisions. It's ongoing. There's no springing, like in the last one with the financial power of attorney. There's no need for a doctor to get certified that you're unable to make these decisions because it's for medical decisions in that case anyways. So with our Nevada statutes, powers of attorney, we have 6 selections on what is kind of pre-fillable, if you will, for our power of attorney that we like to see. California, and it pains me to say this because I really dislike a lot of California's policies, procedures, codes, laws. I think they have a little bit more involved power of attorney set with their code, their California code, than we do. I think ours is a little bit more lean, where theirs is a little bit more involved, which up to them on how they do that, but how we do it here, as we have 6 selections on what you want to have done. You can pick more than one. Some of them complement each other and some of them contradict each other, and you can pick more than one. And I kind of go over those with you here for Nevada, and they're pretty similar across the board, across the nation, of what these selections are. So again, these are informative for your medical providers, that if you're unable to communicate what you want for your wishes, that your power of attorney, your agent, will advocate for you through this document. Oftentimes too, your doctors love having these on file. So that they always ask, if you're going in for a surgery procedure, do you have a power of attorney? Do you have a medical directive? Oftentimes they like their own to be filled out as well, kind of just to cover themselves. But doctors and hospitals and offices love having these on file. So your selections. The first one here is that you want everything under the sun to be done for you, regardless of outcome, hope, survival, cost. I call it the Bionic Woman Clause. We're going to make you a cyborg. We're going to do all the things we can to keep you going. We're going to keep you ventilated. We're going to keep you on a respirator. We're going to keep you artificially fed and hydrated. We're just going to do all the things that we can. Literally, the Bionic Woman Clause. Okay? That's our first selection. The second one is that if you're in a coma and the doctors are pretty reasonable and determined that you are not going to come out of that coma, that you do not want life-sustaining treatments to be used. So they can obviously keep you artificially going, but if you're in a coma and the doctors are like, oh, we don't think you're going to come out of this, that you do not want them to keep you artificially going. Okay. The third option is similar to that, is that if you have an incurable or terminal condition, including late-stage dementia, I say level 75 cancer, that you do not want those life-sustaining treatments to be used. So similar to the coma one, that doctors are like, you're not going to make it, you're not going to survive, that you do not want to be artificially kept going. Okay. The fourth one is that withholding or withdrawing of the artificial nutrition or hydration may result in your dehydration or starvation. That regardless of anything else that you've chosen, that you want those 2 things to be given to you. You want some food and you want some water, because starving and dehydrating to death, might not be the most pleasant way to go. So always keep that in mind as well. The fifth one is that your agent will make that decision for you. That, yeah, we could probably keep you going for another couple months. Probably going to be pretty painful, probably going to be expensive, probably not going to be the choice that you made for yourself. They're going to advocate for you and make that decision for you, okay? They're going to, let's see here, your agent is to reconsider the relief of suffering, the preservation or restoration of functioning, and the quality, as well as the extent of possible extension of your life. They're going to make that decision for you, okay? And the sixth one is kind of the dumbest thing I've ever read in my entire life. That if you have an incurable or terminal condition with no reasonable hope of survival, including late-stage dementia, you're not going to make it. You are not going to make it. You still want that pain-relieving medication given to you regardless of whether you become addicted to it. So think about that for a minute, people. That, yes, I know where they had to come up with something for the opioid crisis. They had to put something in there because we are in a crisis, let's be real. But I'm 98. I have like late stage dementia. I don't know what's going on. I have level 75 cancer and I've got a couple months left. Please give me all the morphine in the world. What? Because I'm going to be addicted for what, a month? 2 months? Yeah, I'll take that. If I'm 25 in a car accident, absolutely, let's have that discussion of whether I want that pain-relieving medication. But the way they wrote that was interesting. But that's what we got in our state here. Many states have very similar directives that way. Some of them are, like I said, in California, a little bit more robust on some of the decision-making decisions there. And we can go over that in a later episode if we want to talk about California. What else is on this one? Again, in our state, we duplicated, do you want to stay in your home? Do you not want to stay in your home? So in the prior one and the financial one, they have, do you want to stay in your home for as long as possible? And if it's safe or no longer safe for you to be in your home, your agent's going to have a discussion with you and place you into a facility. That's the first option. The second option is that you want to stay in your home for as long as possible, regardless of whether it's safe. And if you still want to stay in your home, your agent's going to have to get a guardian appointed by the court to advocate for you for those wishes, okay? Kind of not really good optionality there. Most people have been selecting the third one as they're writing in what they want, that I wish to remain in my home until death. I will obtain long-term care, or I will go live with my kids, or whatever it is. So again, those are your options there. And that is pretty much it for your medical power of attorney. Again, all of these are always notarized, signed and notarized, and those are for your medical wishes. So again, powers of attorney, live when we live. When we die, they die with us. This one was for our medical decisions, for those medical aspects or medical decisions that we need to have doctors make for us on our behalf. So if you like this, please subscribe. Otherwise, you can find me on highsierralegal.com or Instagram and Facebook at highsierralegal.com. All right, thanks guys, bye.